Hi, my name is Stan.
My name is Connie.
My name is Judy.
My name is Eileen, and I'm a caregiver to my mother.
And I care for my mother, Octavia.
And I'm a caregiver for my mother.
And I'm a caregiver to my husband, Art.
I'm a caregiver for my wife, Ann, who's 72 years old.
Basically, I've done everything for providing for both of them.
I take care of my mother on the weekends. I take her grocery shopping.
Not only household chores,
I provide her medical care, coordination, driving, errands.
choosing meals, making meals, cleaning up.
I find that I take care of anything that he can't take care of.
Sometimes I find balancing time a real challenge.
The difficult part for me is taking me into consideration.
Balancing her needs with the needs of my family, the needs of my marriage, and my own needs.
Staying calm, nice, and positive.
The real challenge is, of course, the distance and the moment you get that last phone call.
What I love most about taking care of her is knowing that we're providing a secure and comfortable home for her.
It's the time we spend together.
Is the adventure of finding out new things all the time to trying to help him stay out of pain.
My name is Ed. I'm a spouse and I'm a caregiver.
My name is Colette. I'm a daughter and a caregiver.
I'm a caregiver, and I'm a daughter.
And I'm a wife and a caregiver.
I'm a daughter and a caregiver.
I'm a son, a nephew, and a caregiver.
Hi, my name is Deborah Day, and I help manage United Way Caregivers Coalition. While caring for a loved one has its special rewards, it's a very challenging job. It can be stressful, overwhelming, and sometimes lonely. Each caregiving situation is unique, but all caregivers share the need for information and support. And that's where the Caregivers Coalition comes in. We help caregivers receive the support they need to take care of their loved ones and to take care of themselves. Caregivers who lead healthy, productive lives will be better caregivers. The most important thing to remember is that as a caregiver, you're not alone.
Good evening, everybody. As Ruth said, I am Tom Murphy, and I am an elder care attorney. Tonight we have a lot of information to cover, and probably the place where I like to start out, though, is with the story. And my story is about a good friend of mine. Her name is Doris. And I first met Doris in an assisted living facility a number of years ago. And what struck me about her was every time that I would go see her, she was with her husband who had late-stage Alzheimer's, and she would just sit with him in the corner. And they were kind of off in the corner, and I was just struck by the loyalty and the devotion and just simply the love and caring that she had as a caregiver. And then one afternoon, I went into the facility and I saw Doris, and she was all upset. And I said, Doris, what's the problem? Why are you so upset? And she said, Tom, I don't know. I went to the bank and the bank wouldn't give me any money. And so I'm beginning to think to myself, okay, what's going on here? Can you tell me a little bit more, Doris? And she said, well, you know, I used to have my bank account and my husband had his bank account. And to pay for all the bills, I would go to the bank and take money out of my bank account. And then all of a sudden, when I ran out of money from my side of the bank account, I went over to his and they said I couldn't get anything unless I had a power of attorney. And I don't have that. So what am I supposed to do? Now, immediately my lawyer hat goes on as I'm trying to sort of figure out what's really going on. And I kind of thought to myself, gee, if we have a couple here, and by the way, they had no children and very little family, and if they had his accounts and her accounts, they probably had some lawyer years ago set that up for for tax planning purposes, and there probably is some sort of power of attorney somewhere around. And so I sort of, said to her, by the way, do you have a safe deposit box? And she said, oh, you think it might be in there? And I said, well, that's a good place to look. To make a long story short, about 3-4 hours later, I'm driving in my car, I get a call on my cell phone. It's Doris. She said, I went into the safe deposit box, and this is an absolutely true story. Not only was there the power of attorney, but there's all these sort of gold securities and stocks and all that. And lo and behold, there was literally millions of dollars in the box. True story. Now, I have always said to myself after that, I promised Doris that I was always going to tell this story, because there's two critical lessons out of that story. First of all, every one of us here, prior to leaving this world, are going to have a period of time when we can't make any decisions. I know for myself that there will be a period of time when Tom Murphy cannot take care of his bank account and Tom Murphy cannot make any health decisions. The only thing I don't know for me is whether or not it's going to be for 5 minutes or for 5 years. So I have the opportunity now to execute a document called a power of attorney to give my wife, and if not my wife, my 2 sons, the legal authority to be able to make those decisions. I never want to see anybody go through what Doris went through for that 24-hour period when she didn't know how in the world she was going to pay her bills. The second lesson out of that is we have to communicate. It does us no good to put all of these plans together and then not talk to our family members about what our wishes are and what we need to have done. Now, very often kids will say to me, gee, whenever I talk to my mom or dad, they don't want to have the discussion. And I remember with my dad, I said to him once, hey, Dad, can we talk about your will? Guess what his response was? The finger came out, this finger. And it was, Tommy, if the day I die you get a penny, that's a penny more than you had the day before. That kind of shut down the conversation. So there might have been a more effective type of communication. But the point of the story is, if we're kids, we should go to our parents and say, I love you dearly. I just want to make sure that when the time comes, I'm able to carry out your wishes. And if we're parents, we need to say to our kids, I realize this might be a tough conversation for you, but I need to be able to rely on you. You need to know what my wishes are and where my documents are. And what I would suggest is remember the Doris story, because we never want to see anybody going through that. So, what are the key documents? I kind of think in terms of, first of all, I sort of have to apologize for the legal profession, because we've done a horrible job of naming these things and communicating these things. We have power of attorney, we have durable power of attorney, we have springing power of attorney, we have healthcare directive, healthcare proxy, we have medical directive, we have advance directive, we have living will, and the list goes on to the point where basically anybody I have a conversation with, until I start asking them about what they think the particular document is, it's very hard to understand. So what I would suggest to do, first of all, forget everything you've always learned. Think about what it is that we need to achieve. For myself, when I become disabled and can't make decisions, I need someone who's going to be able to take care of my banking, to make financial decisions for me. So let's just simply call that the power of attorney for financial matters. I also need somebody to talk to the doctors to figure out what the best medical procedure and practices are for me. Could be the same person, but let's call that power of attorney for health matters. And let's try to, again, think in terms of what outcome we're looking for, and then worry about having the lawyers figure out what document does that. But a power of attorney for financial matters, a power of attorney for health matters. The third document is the living will. To me, the living will is nothing more than a set of instructions to my wife and to my children about how I feel about a small subpart of health decisions, and that's end-of-life decisions. And for the most part, what I want my power of attorney, or I should say my living will, to do is I want to make sure that when it does come to the end of my life and decisions have to be made, that there's a legal document that gives my wife and my 2 kids a lot of authority, as much authority as they can possibly have, so that they're the decision makers for me and not necessarily a doctor, a hospital, or God forbid, the lawyers for the doctors or hospitals. And so those are, to me, the 3 key documents that we all need to make sure that either we have or as caregivers, that the people that we are caring for have for us. Having said that, what are kind of the common questions that I come across when I talk to people about these documents? One of the first things people normally ask me is, well, who should I name as my power of attorney? Very often I get a mom or dad who comes to me and says, I have 6 kids. I love them all. I don't want to hurt anybody's feeling. Can I put them all down? I can tell that you don't think that's a good suggestion. The last thing in the world, I love my family dearly, but the last thing I want to hear is when they're rolling me into the emergency room, 6 people having a discussion about what should or shouldn't be done. So that what I normally suggest is that where possible, have one key decision maker, but make sure that on that document, that key decision maker is backed up by another person and backed up, usually I suggest, by a third person. The second aspect of that is how do people go about deciding who that key decision maker is? There's probably, I would say, 3 different methods that people use, and any one is fine. It's just whether or not you've applied the logic of thinking it through. The first method is what I call the seniority system. I have my oldest followed by my next, followed by my next. That's how we've always kind of made decisions in the family, and that's what I want to continue with. The next is geographic location. My daughter lives right next door. If there's a phone call at 2 o'clock in the morning, she's the one who's going to be in the emergency room. So let's make sure that she has it. And then the third is what I call area of expertise. My son happens to be an accountant. Let's let him make all the financial decisions. My daughter happens to be a doctor. Let's have her make all of the health decisions. Either one of those ways is fine. It's just that I, as an attorney, always like to just have the person talk through with me how did you reach the decisions that you reached? Because it is probably, in my mind, one of the most important decisions that you're going to make is when that point in time comes, when you need someone to make financial and health decisions for you, who is the person who's going to be making that decision for you? Another issue a question which often comes up and people ask me about is, what is a durable power of attorney? They often say to me, Tom, I must have a durable power of attorney. What does that mean? Well, actually, you should have a durable power of attorney, and it means nothing more than when you become disabled, this power of attorney is still in effect. And usually when I say that to people, they go, duh, isn't that what we're doing? And to make a long story short, the common law of powers of attorney is the opposite of that. And so every one of these documents that are prepared for situations in which we consider a power of attorney should have a little clause, a little sentence in it, which just simply says, upon my disability, this power of attorney is still in effect. Now, those sort of issues or decisions tree as far as the financial power of attorney go also really apply to the power of attorney for health matters, or sometimes, again, what we call the medical directive, the medical proxy, the healthcare proxy, the healthcare directive. The only additional thing that I like to make sure is in the document is what they call a HIPAA release. There is a federal law which basically says that for a doctor or hospital to share your private confidential medical information, there must be a specific release. So you want to make sure that that information is in that particular document. Now, moving away from sort of the key planning documents, I often get asked and get into sort of a question in terms of how do we handle some of the key assets that we own? How should we handle the house? What about the bank accounts? What about the IRA that we have? And I think about all of those documents very, very differently. And again, I'm going to bore you with another story. I got a phone call from my dad, and this was kind of after we talked about after we had our first discussion. And he said, "Hey, Tommy, you're a lawyer, right?" And I said, "Yup, I'm a lawyer." He said, "Do you know anything about wills?" And I said, I might know a thing or two. And he said, "Well, why don't you come down to North Carolina and take a look at mine? I have a few questions." And so I drove down and I saw him, and I looked at his will, and there was a little provision in his will for his sister, my aunt. And I said, "You know, Dad, Aunt Beryl's never going to see this $10,000. And he looked at me and he said, "What in the world are you talking about? It says it right here in my will, $10,000 to my sister Beryl. What about that can't you read? I thought I educated you at a fine university." And I said, "Dad, it's not always just the will. It's how you own your assets. Who do you own your house with?" "My stepmother, Betty." "Who's the beneficiary of your life insurance?" "My stepmother, Betty." "Who's on your bank accounts?" "Well, my stepmother, Betty." So if you die tomorrow, Dad, this will doesn't even come out of the draw, because it's all a matter of how your assets are titled. And so when we're talking about assets and we're talking about wills, if you want to make sure that what it is that you intend to have happen when you die actually happens, you not only have to look at the will, but you also have to look at all your beneficiary designations, and you also have to take a look at how you own your assets, whether or not they're jointly owned, rights of survivorship as such. And it's taking that sort of holistic approach and examining that to make sure that what it is that you want to have happen does in fact happen. So kind of moving on to that, it's what are some of the different, what I call asset groups that we have. And for me, I see them falling into sort of three different categories. The first category is often the house. Now, most of my clients were in World War II, were in the Korean War, came out, and they bought the house in the suburbs. They bought their house for probably less than what I paid for my last car. And now 50 years have gone by, and guess what that house is worth? A lot more money. And so it's what we call a highly appreciated asset. For the time being, I just want you to kind of remember just simply that there's a group called highly appreciated asset. The second thing that often happens is during people's lifetime, they have 401ks, they have IRAs, and they've put money away in which the IRS calls it qualified money. Qualified money means nothing more than it was investments in which that money has never been recognized as income. And when you withdraw that money, it will be recognized as income and you pay income taxes on it. And so again, just let's put that in a bucket and call that qualified assets. The third category is just everything else. You know, your checking account, your savings account, and those particular assets that are neither highly appreciated or there's special income tax treatment with it. So then as myself as a planner, when all of a sudden a couple comes to me and we're trying to figure out how to go about paying for the 24/7 home health aid or the assisted living facility or the nursing home, one of the things that we're going to start taking a look at is the different buckets of assets. Now, the first thing we know is with a house, if it's a highly appreciated asset and we pass away and we leave it to our son or daughter, they receive it at what is called the stepped up basis in value. And so if it was worth $20,000 and now it's worth $620,000 and our son or daughter inherit that, their cost basis will be $620,000 and there won't be capital gains tax that has to be paid on that. And again, I'm going to come back to that for a second. I just want you to remember that thought. So if we're in a situation where all of a sudden we have extraordinary costs of maybe $6,000 per month in which we have to use to pay for assisted living costs, for example, which is an unreimbursed medical expense if the assisted living is prescribed by a medical doctor. And if we take out of that IRA to pay for that, yes, we will recognize some money as income. And by the way, I'm a lawyer, I'm not an accountant, I'm not a CPA, this is not tax advice. Go seek tax advice from your accountant, but I would suggest having this conversation with them. If we use the money from the IRA and recognize it as income, but use it to pay for an unreimbursed medical expense, we can perhaps maximize some of the tax issues around paying for 24/7 home health care, assisted living expenses, or nursing home expenses. Again, I would suggest having that conversation with your accountant, but all money is not the same, is really sort of the takeaway from that. Now, people often will ask me, what about bank accounts? How should I title my bank account with my daughter? There's basically three ways when people come to me and say, my daughter's name is on the bank account. That itself doesn't tell me all that much. It's a matter of, is her name on there as a power of attorney? Is her name on there as a joint owner? Or is her name on there as somebody who is a beneficiary of that account, or what we call POD, payable upon death? The reason why I just sort of highlight this and say that it's something that you should think about is because usually the discussion stops at just simply, I put my daughter on the account. Each of those ways have different legal significance of what that means. A power of attorney means that while you're alive, they have access to help you with that account. A payable on death means upon your death, that account gets paid to that person like a beneficiary of a life insurance policy. And then the third way, joint owner, means that they are in fact truly a joint owner of that account, and it's not necessarily controlled by what your will says. The significance, again, is a matter of what it is that you're trying to achieve when you take your son or daughter and put them on that particular account. Having said that, I want to go back a little bit to the house, because very often, I'm sure each of you have kind of heard someone come up and say, you know, I'm concerned about nursing home costs, and we're concerned about losing the house, and therefore I took my son's name and I deeded it over to him. Is that a good thing, or is that a bad thing, is often the question that will come to me. And like all good lawyers, I say, well, maybe yes, maybe no. It depends, again, what you're trying to achieve. But the things that we're thinking about is, first of all, if it is a highly appreciated asset, And we've taken that highly appreciated asset as the homeowner, and we have deeded it away to the son. It's not our son's primary residence. Therefore, if it gets sold, there is not favorable capital gains treatment that the owner of the primary residence would have. And the second thing is that if we should die, we've missed the opportunity of being able to have then inherit it at the stepped up basis in value. And so there may be a significant capital gains tax as a result. Very often, a better way to achieve the same goal is, instead of taking the house itself and gifting it to son or daughter, is to use what is called the life estate, or to use a irrevocable asset protection trust to be able to achieve some of the same things. Now, I'm not going to necessarily get into both of those strategies tonight. I just sort of, again, wanted to highlight it. But while I sort of say the word trust, I also want to just talk a little bit about some of the common terminology that is used with that particular term. First of all, I myself hate the word trust. And the reason why I say that is it doesn't say anything to me. It's like saying the word contract. Contract doesn't mean anything unless you read the 52 pages of the contract as far as what it is trying to achieve. The same thing with a trust. A trust itself doesn't really have that much meaning. It's a matter of what are you trying to achieve through the use of this particular vehicle. I often like to say that it's nothing more than just simply a written agreement between mom and dad and often their children. And if we take the example of the house, perhaps what we want to do is we want to protect the house, and we want to protect it and start the Medicaid 5-year look-back rule, which we'll get into in a second or two, and get the house out of our name. Well, we set up a written agreement in which we, as the parent or the grantor, are taking this asset, the house, and transferring it into this entity that is going to be managed by what is called the trustees, by son or daughter, and ultimately son and daughter are going to be the beneficiaries of this agreement. So the three parties to the trust are what we call the grantor, the person who owned the property that's being transferred, the trustee, the person who's going to manage the property within, or the assets within that vehicle during our lifetimes, and then the beneficiary, the person who actually is going to be able to benefit from either the income of the asset or the principal behind the asset itself. And those are, again, the key terms. When we think in terms of what we often call, we lawyers call, an asset protection trust, what we're trying to do is similar to the situation I said before of take the property and get it out of our names by giving it to our son or daughter, in which case the trust or the written agreement has two important sort of features to it. The first feature is it's irrevocable, and I'm sure that you've all heard that term. What that just simply means is after I take the property and transfer it into the trust, I, as the grantor of this trust document, I don't have any right to change the terms of that particular agreement itself. The other aspect of it is that particular agreement or trust needs to say that I am not a beneficiary of that. And when we think about taking the house and deeding it to our son and daughter, we've done the same thing. From a legal standpoint, when we've done that, we have no legal right to say, I've changed my mind, I want it back. It's irrevocable. And we've also really don't have any legal right to say we're the beneficiary of that property because we have transferred it over to that person. The advantage of doing it the trust method is just simply that when I think of my two boys, I completely, I hate to use this word again, trust them. I don't have any issue that they're not going to always be there to help dear old dad and mom. But they can't promise me that if I take the house and actually give them that property, they can't promise me that they're not going to get divorced. They can't promise me that they're not going to die. They can't promise me that they're not going to get sued or go bankrupt. And if we've actually have taken the house and deeded it over to them, all of those four things could be unintended consequences of our action, whereas the trust keeps that property from being kind of commingled with whatever may happen in their particular lives. Having kind of talked and kind of touched upon all of that, and I apologize that it's been such sort of a quick surface manner, but I just want to sort of highlight some of the key issues. A lot of times people will say to me, gee, I thought you just kind of use a trust to avoid probate. And while that may be an objective, my particular experience is that probate is really not a four-letter word here in New Jersey. Our surrogate offices are extremely, extremely helpful in being able to help people process through the administration of an estate and work very, very effectively with families. Another aspect of that is, remember now, federal estate taxes really don't even come into play until after $5 million. Yes, in New Jersey, we do have a New Jersey estate tax and we have New Jersey inheritance tax. But from a tax standpoint, it is really not, very few of my clients, we really get into the type of tax planning that perhaps would be a reason to either have a tax planning will or do some tax planning within trusts themselves. But people will ask me, what are the tax issues that come into play with an estate? And I normally say we need to really sort of talk in terms of what taxes are we talking about. Federal estate tax is above $5.35 million. New Jersey estate tax above $675,000. Inheritance taxes, if we're son or daughter, we're Class A beneficiary, and we can inherit an unlimited amount of money without any tax consequences. I want to touch on, very quickly, on sort of some questions that often come up around veteran benefits as well as Medicaid benefits themselves. And probably the thing that I would say about Medicaid benefits is that, remember, we have the 5-year look back, which, for the most part, most people who come to see me recognize now that it is 5 years. It's not 2 years, it's not 3 years. And what that just simply means is that when we apply for Medicaid, there is going to be a review of the last 5 years of all financial transactions, and where there is what is called an uncompensated transfer. We had $1,000 in our pocket, and we gave it to son or daughter, and we received nothing in return. Some people call that a gift as well. What Medicaid is going to say, and probably properly so, is, gee, if you kept that money, there would have been another $1,000 that you could have been paid for your care. So before you ask other taxpayers to pay for the nursing home, either get that money back, or it's not illegal, but we are going to have a period of suspension, they call it penalty, before we actually start paying for those particular benefits. Now, one misperception that often comes about is people will say, I thought I could gift away $13,000 per year per person. And that is an IRS regulation. It's not a Medicaid regulation. And so you don't want to be in a situation where for the last 3 years you've had 22 different grandchildren and you've given them each $10,000 and then say, well, I followed IRS regulations. Medicaid will say, you followed IRS regulations, but we don't follow IRS regulations. If you were that rich to have all that money to do estate planning, go get it back and use it to pay for the nursing home itself. And that can be a real shock when you hear that for the first time 3 months before you're ready to apply for Medicaid for mom or dad. Another benefit which is out there is what they call the aid in attendance pension benefit. The aid in attendance pension benefit, it's been around since 1951. It's often called one of the best kept secrets. And for a husband and wife, a veteran and their spouse, if they start having unreimbursed medical expenses which exceed their income, which if they're looking at a nursing home, if they're looking at assisted living, if they're looking at 24/7 home care, in most cases those expenses are going to exceed their income. They're able to apply if they are a combat war veteran, which means that they have 1 day of service during combat. They're able to make application for this particular benefit and receive up to about $2,000 per month for veteran and spouse, roughly around $1,600 per month for the veteran, and for a surviving spouse of a veteran, about $1,000 per month or so, which can be a very, very important additional source to help with the cost of 24/7 care or assisted living or nursing home. And so I want people to remember that. Lastly, remember also in New Jersey, we have three what we often refer to as New Jersey soldier homes. Those are facilities which have a different cost structure to them, for a New Jersey veteran, can be an excellent way to be able to also fund some of the cost of care. Again, what I tried to do this evening was I really tried to kind of highlight, all of the different conversations that I have during the course of a week into 30 minutes. So I appreciate your patience with trying to let me kind of hit certain things on surface. But my key takeaways are: make sure you have a financial power of attorney in place, healthcare directive. You have your expression about how you feel about end-of-life decisions. Take a look at how you own your assets. Take a look at your beneficiary designations. Take a look at your will, and make sure those documents, in fact, achieve what you think they're going to achieve upon your death. Think in terms of your assets, and think in terms of perhaps maybe at some point post-75, it maybe makes some sense to, at that point in time, having assets in your name. Probably don't do a heck of a lot of good for yourself, and figure out how maybe the best way to plan and position that. And lastly, make sure you communicate to your loved ones what your wishes are, so that they understand what it is that you expect out of them. I really want to thank you an awful lot for your attention. You've been a great, great group to talk to. The question is, what is the difference between a durable power of attorney and a springing power of attorney? A springing power of attorney. Let's first of all talk about what a springing power of attorney is. A springing power of attorney is contrasted against an immediate power of attorney. Springing power of attorney says, upon two doctors certifying that I am unable to make financial decisions or health decisions, upon that certification, this particular document gives authority to my spouse or my two children to be able to make those decisions for me. Upon my disability, that's when this document springs into action. An immediate power of attorney is just simply a document in which I say, my wife is my power of attorney, backed up by my son and backed up by my other son. Generally speaking, I strongly advise all of my clients to have immediate powers of attorney, just simply because the last thing that you want in the middle of a crisis is to find two doctors who are able to certify the disability of the loved one that you need to make decisions for. Separate and apart from that concept is the durable power of attorney. The word durable says something else. The word durable just simply means upon my disability, this document is still in effect. You want to have a durable power of attorney whether it's immediate or whether it's springing. And the springing or the immediate just simply describes when the condition upon which that document goes into effect. How can I tell the difference between immediate and springing when I'm and durable? Okay. Okay. You can tell a document is durable two ways. One is a good durable power of attorney is going to say durable power of attorney. But more importantly, inside the body of the document will be a sentence, upon my disability, this document remains in effect. And that's the sentence that makes it durable, and that is the key sentence that's in there, okay? Okay, the question is that I had said before that very often people will come to me and say, I am on my mother's bank account. And what I said was, that to me doesn't mean anything because I need to know how you are listed on it, whether you're a joint owner, whether you're a beneficiary of that account, or whether you are power of attorney for that account. That is a very specific legal question which the bank somewhere, okay, had someone fill out a form which either said, Mom is making me power of attorney, Mom is making me the beneficiary or POD, or Mom is making me a joint owner. And so it becomes very important to ask the follow-up question of, Mr. Banker or Ms. Banker, when you say I'm on this account, how am I on the account? What are my rights to this account? And each of those types has very, very specific consequences of what you can and can't do and when. The question is what are the consequences of moving state by state, either on a permanent basis or a temporary basis, and how does that come into play? And there's a few different layers to your particular question. The first question that often comes up is people will say, I just moved into New Jersey, are my documents that we did in Florida or Colorado still good? My answer is going to be a bit of a lawyer answer, and maybe, probably yes, but my real answer is, if you're moving permanently to another state, you should have someone within that state sit down, review your documents. You should understand what are some of the subtle differences between one state and another state, because it can have some planning consequences to it. The second part will be, my family often asks me, and most of my family does not live in New Jersey, my extended family, oh, Tommy, you're an attorney. Can't you draw up our will? And we live in Florida or North Carolina or California or whatever. Normally my advice to them is you should really sit down with an attorney in your state who's familiar with that particular subject expertise, and there's the old adage of you get what you pay for, and you should really, with something as important as your final distribution of what you own, you should spend the time to sit down with somebody in that state who's aware of that. If you're in the middle of traveling from one state to another and you happen to have the accident and die in a state other than your own, if that happened to me, I'm a resident of New Jersey, and things would be probated in New Jersey under New Jersey law and jurisdiction. This is what I normally suggest to people, and the question is really, gee, I went to this attorney, he drew up a power of attorney, and it was a real nice document, and that attorney was a very nice, helpful person, but the first time I ever pulled it out and I went down to the financial institution, they said, well, we have our own form, please fill out our own form. Now, a legally executed power of attorney in the state of New Jersey for a financial institution that wants to do business in New Jersey, they're legally bound to recognize that properly executed document. But there is also an adage, and now I'm taking off my lawyer hat, of sometimes you can't beat City Hall. And what has happened with many of the banks, my theory, no one in the banking industry has ever told me this, but as our local banks have gone to national banks, and as the banks are dealing with 50 different regulations across many of the states, they've had much more of a movement to just sort of standardize across all of their branches and not necessarily, have their folks always as well trained in New Jersey banking regulation, perhaps as I would like to see them have. I'm sure if they're watching this, they might disagree with me on that. So what I normally suggest to people is do the following. Is after you come to my office and execute a new power of attorney, or anybody's office, with mom or with daughter or son, take them down to the bank and say, this is my son or daughter. This is the power of attorney that we have in place. I want to introduce you to my son or daughter so that when there's a crisis, you know who they are, and you know that I want them being able to handle my affairs. Now, this is the document that my attorney executed. Give it to your lawyers, have them take a look at it. If there's more papers that you want us to fill out, we're fine with that. I just want to make sure before there's a crisis that you know who I am, what the papers are, and that my son or daughter has legal authority to be able to help out. And that's normally the suggestion that I make, is to as much as we can to sort of communicate beforehand before the crisis occurs. Okay. Your question is a question of who gets what, when, and why, to some extent. And if you take out a life insurance policy, you've entered into a contract with a life insurance company that when you die, so-and-so gets paid this money, okay? Your will does not trump that contract, okay? When you go to the bank and you create an account with your spouse in which both spouses have rights of survivorship, if one of those spouses die, the other spouse has the rights of survivorship and own that particular account, and the will does not trump that just because you wrote a will that says something else. When you go to a house closing and you buy a house with your spouse as husband and wife with, again, rights of survivorship, and one spouse dies, the other spouse legally owns that. We call that almost by operation of law. So that if that person just had life insurance, a joint bank account, and property, when they die, there's no asset that the will controls, because they've already said who they want owning that property upon their death. Everybody should do is everybody should put together basically an inventory of the things that they own. They should then understand with each of those assets, if they were to die tomorrow, who would this asset be transferred to? And if in fact, after they do that exercise, that reflects what it is that they want, they have done some successful planning. If, on the other hand, it is a confusion and it doesn't reflect what they intend, they should really sit down with somebody who understands entitlement of property, beneficiary designations, survivorship options, and will. And together, my point is really you can't just simply look at one document and assume that that is going to control every asset that you have, because there are things such as jointly owning property, and there are things such as beneficiary designations that may end up with a different outcome than what it is that you intended. Okay, the question is often when somebody goes into a hospital under Medicare regulations, a hospital is required to present you with some information, including information that you have a right to name somebody to be your healthcare proxy, and that you have a right to express how you feel about end-of-life decision-making. And often people will sign forms upon the entry because they're presented. And sometimes hospitals do a good job of explaining. Sometimes they do maybe less than a good job of explaining. And the question is what I filled out there trumping what other documents that I may have? Without seeing the documents, I'm going to take a little bit of a punt. Without seeing the documents, it's hard to really sort of completely answer that question specifically. But in a more general, the lesson and takeaway that I have with that is that prior to going into the hospital, you should clearly understand what it is, who it is that you want as your decision maker, how you feel about end of life, how you feel about resuscitation or non-resuscitation DNR orders themselves. Have a conversation with your doctor who's suggesting the hospital stay, and kind of, come to a firm understanding of what should be reflected of that. Have your documents ready, and when presented with that, be able to say to the hospital, well, thank you very much for your form documents, but here are my documents, and these are the things that I want to have done, versus kind of in a reactive mode, just kind of filling out paperwork that is in front of you that you may or may not completely understand what it is that it says.